Good afternoon, everybody. I'm Samantha from the law offices of Samantha Wolfe, and today we're doing our monthly virtual seminar. So thank you for everybody for being on. Let's go ahead. I'm going to share my screen. Today we have a fun, timely holiday presentation. So today what we're going to talk about is Don't Be a Scrooge, the ins and outs of gifting. So we've done a lot of different virtual seminars where we've talked about gifting as part of it. But today we wanted to devote the entire session to gifting. And what does that mean for the person who is gifting and for the person who's receiving it? And I know my mom's on the phone, so hi, Mom. Don't worry, I'll be using our family again as examples in the gifting strategies. So I'm glad she could be on today. All right, so let's talk about gifting. Today, what we're going to do is we're going to start off with the basics of what is a gift. Okay, so I always think that's fundamentally where we need to start because I think that when I meet with a lot of clients, they have an understanding or what they think a gift is. And then as we're talking through things, they realize that maybe transfers they've made in the past or a planning idea that they thought they would use in the future is actually a gift. And there are tax consequences as well as legal consequences of that. So let's start off with what is a gift. So I picked a couple of examples of situations where a gift occurs. So the first thing to know is anytime there's a transfer, whether it be of money or of an asset, if we transfer and it's not for adequate consideration, meaning that as the holidays are coming up, if my parents wanted to gift me $1,000 and they're not doing it for some job I've done or some sort of compensation, they're just doing it because they love me so much, they're giving me the gift, then there's no consideration for that. I'm not doing something in order to receive those funds. So that would be considered a gift. We see this a lot of times in deeds. So either we'll have client come in with a deed or they'll come in saying, I want to transfer my deed, but I want to do it for $1. And it's not a gift because it says $1 in there. So I don't have to worry about any of the gifting rules. And the reality is that if you are transferring real estate and on the deed it says $1, then how the IRS as well as the state of Pennsylvania looks at that is a gift, because that's not what the property is actually worth. There's a fair market value for that property. So anytime that you're transferring real estate, we see most often, but you're transferring it and you're saying, well, we're doing it for $1, that is a gift that you're transferring. Anything for less than fair market value. And the easiest way to figure out what fair market value is for real estate is if you go to your tax assessment card, there's usually a tax assessed value. And what you have to do is you have to take that value and multiply it by the common level ratio factor. So Franklin County every year has a factor that they come out with January 1st. The whole state of Pennsylvania does it. And the factor is a number that you multiply the tax assessed value, and that will give you what Franklin County says is your fair market value. So I just am working on one where the tax assessed value is $20,440. And what we do is we multiply it by 9.43 because from July of 2021 to June 30th of 2022, the common level ratio factor for Franklin County is 9.43. So if I take the 20,440 and multiply it by the 9.43, that would give me what Franklin County says is my fair market value. So when you're transferring something, that's the minimal amount you would use. And that would be for gifting purposes, both at the federal level and at the Pennsylvania level. Now, sometimes people decide to get an appraisal because they know that if you take the tax assessed, you multiply it by that common level ratio factor, it's either going to be more or less than what they think the fair market value actually would be if they sold it. So you have to use either an appraised value or you have to at least use the tax assessed times that common level ratio factor if you want to be selling it for fair market value. And we're going to talk about the importance of that as it relates to gifting for federal estate and gift tax purposes, as well as for Medicaid purposes. What we're going to try to do through this seminar is talk about it on both sides of the coin there. So Medicaid planning, as well as if you're doing federal estate and federal gift tax planning. Another way in which you're actually making a gift that we see a lot is if you made a loan to someone and you aren't collecting interest. So sometimes parents will say, I loaned my child $20,000, they're going to pay me back, but they're not actually going to pay any interest. The IRS would actually say that that interest amount that you're not charging that individual would be a gift. So, and again, if that amount is above what the annual exclusion, which we'll get to in a minute, but it's 15,000. If that interest is above that, then you have to file a gift tax return. If it's not above that, then it's still a gift. It's just qualifies as under the annual exclusion umbrella, so you don't have to file a gift tax return. But the important thing to know is if you're loaning something money or any other type of asset you're loaning, but you aren't charging an interest, then you've made a gift to that individual. Another way that we see it is where you're adding a child's name or children's name to real estate. So if my mom and dad decided to add my name to the deed of their real estate of their primary residence, technically that is a gift to me. And that's a gift for Medicaid purposes. That's a gift for gift and estate tax purposes. And there are a lot of issues that come with that. So when a client comes in and says, I want to add my child's name to this deed or to this account or to this asset, we want to talk about what does that mean for creditor purposes, but we also want to talk about what does that mean for gifting purposes. And so it's important to know that adding a child's name to an asset, real estate, as well as a bank account is going to be considered a gift. The last example I wanted to give you was if you transfer your home. So let's say mom and dad said, we're going to transfer our house to you, Sam, but we're still going to live there and we're not going to pay rent. Technically, if I'm the owner of that real estate and out of the generosity of my heart, I'm allowing my parents to live there without paying rent, then I'm making a gift to them of that. There's also some implications for inheritance tax purposes because they would say if the property is transferred and you're not paying rent, then Pennsylvania has what we call an implied life estate, which means that even though you transferred it to get out of your estate thinking, well, if I do that and survive it by 1 year, there'll be no inheritance tax. Pennsylvania is going to say, oh, no, we're still going to assess the inheritance tax. So you have to be careful with that. But that's another example where we see an issue with a gift, because if you're not paying rent, but you don't own it anymore, then technically the new owner is making a gift to you of allowing you to stay there without paying rent. So that's bottom line is a gift is anything where there's not adequate consideration. So with that being said, let's talk about two types of gifting. So we have federal gifting, and that would be both federal estate and gift tax implications. And then there's Medicaid gifting. And the Medicaid is something we're going to discuss on the latter half of the presentation. But it's a common misconception when a client comes in and they say, how much can I gift in a year? They're thinking the federal estate and gift tax annual exclusion amount, which is $15,000. It will go up to $16,000 starting in 2022. So you get an extra $1,000 starting in 2022. But for Medicaid purposes, any amount that's over $500 a month is actually considered a gift for Medicaid purposes. So when a client comes in and they say, how much can I gift? It depends on what type of implications we're talking about. Are we talking about federal gift and federal estate? And if so, then it's $15,000, soon to be $16,000 or less. But if it's for Medicaid, it's any transfer over $500 in 1 month would be considered a gift unless there's adequate consideration. And that's going to apply even if, again, it's not a gift for federal estate and gift tax purposes, it could still be a gift for Medicaid purposes. So federal gifting, what the buzzwords that the IRS uses would be, is there adequate consideration? And did you have a loss of dominion and control? And this is important because we're going to talk on the second half of the presentation about trusts that we use for Medicaid gifting purposes to protect assets, but there are still going to be federal gift and federal estate tax implications for the use of that trust. And so it's important to know, did you lose dominion and control? Meaning that did you transfer it to somebody and you no longer have the ability to control and you no longer have that asset in your possession? Easiest thing would be cash. So if I write a check out to one of my nieces and I give them the check, then as soon as they cash that, I no longer have dominion and control over whatever that check amount was for. So the gift would be considered complete at that point. So it's always a question of when is the gift complete and when did you lose dominion and control over the asset? And we'll talk about that as it relates to trust as well. We have so many fun things to talk about when it comes to gifting. I want to start before we really get into the tax implications by just reminding everybody that you want to make sure that your financial power of attorney does address the gifting issues. So here at our office, we do advocate that for gifting purposes, you may want it to say unlimited gifting. You may want the word unlimited to be attached to any gifting powers in the financial power of attorney. And the reason is because if you don't say the word unlimited, then in Pennsylvania, your agent can only gift whatever the annual exclusion amount is. So again, right now that's $15,000. It'll go up to $16,000 in 2022. So if you don't use the word unlimited, then the agent can only transfer the $15,000 or the $16,000. So for those of you who have powers of attorneys, you just want to go check it, make sure it has the word unlimited gifting. A lot of times, if you have a power of attorney that was drafted after 2015, it's going to address that in there because that's when the law had the last major shift. So if you've had anything done by our office, it does have the unlimited gifting language in there unless a client, when we review it, specifically asks for that to be removed. And also, it's important to know that that gifting language applies even between spouses. So if my mom and dad, for example, if one of them went into a nursing home, I always pick on my dad. Let's say he goes into a nursing home and my mom wants to transfer assets from dad's name into her name, maybe for some Medicaid reasons. My mom would have to be given the power to make unlimited gifts, even between my parents. So you want to make sure you have that language in your financial power of attorney. So go home, make sure to check or pull it out there and take a peek at it. The next thing I wanted to go over is the federal estate and gift tax exemptions. So I thought it would be helpful for purposes of this to show you what historically the federal exemption has been. So know that as long as I've been practicing law, the federal estate and federal gift tax exemption have been one coupon, meaning that you have the option to gift assets during your life or at your death, as long as those combined gifts don't exceed whatever the exemption is, then we don't have an issue. You don't have to pay tax. But if you combined gifting during life and at death exceeds whatever the exemption amount is, then you're going to pay tax at either, as you can see, historically, it was as high as 45%. Currently, it's 40%. So I've never had to deal with uncoupled gifting. And I bring this up because in the spring, when President Biden was talking about what he was proposing or what was going to be on his tax agenda, one of the things he mentioned was that he wanted to uncouple the federal gift and federal estate tax exemptions, meaning that during life, he wanted to say you can only gift so much. So actually what the proposal that he had put out there was he said that not only did he want it to cap the gifts, total gifts you could make during your life, but he also wanted to cap the annual exclusion. Because as we're going to see in some of these later slides, the annual exclusion amount, which is that $15,000, soon to be $16,000, that you can gift to as many people as you want without having to file a gift tax return, without having to worry about that. You can do that to as many people as you want. And Biden's proposal was that he would actually cap that. So instead of being $15,000 per donee, it would be a total of $20,000 per donor. So instead of being able to give $15,000, if, for example, my parents' case, to all 4 of their children, they would only be allowed to gift total in 1 year without using up some of their exemption, $20,000. The other thing that Biden was proposing is that if mom and dad wanted to give $20,000 in 2021 and then wanted to turn around and do it in 2022, not a big deal. But if they wanted to give an amount over the $20,000, that starts using up their gift exemption. And the gift exemption he was proposing was going to be $1 million, meaning that mom and dad, if they gifted over $1 million, now remember that $20,000 wouldn't count towards that. So anything above that $20,000 in 1 year would start working towards eating away at that million, Once you hit the million, then you would be taxed at the 40. He'd actually proposed 45%. And then at death, you would be able to transfer the rest. So if in his proposal he wanted to drop the exemption to 3.5, that just meant that maximum during your life you could only get to 1 million. And then when you died, assuming you used that whole million, you had 2.5 that could be transferred at your death, but you couldn't gift the whole 3.5 during your life. It had to be 1 million. As soon as you went over 1 million, you were taxed at 45%. So I say that because as soon as it gets on the agenda and it's out there in the news, one, people hear about it and they worry about it. Number two, from a planning perspective, that just tells us what are they thinking? So in the future, what are we likely to see coming out of Congress? And so the fact that we have seen President Biden propose the uncoupling of the federal gift and federal estate tax, it would be likely or possible that we could see any proposals coming out of his party, the Democrats, uncoupling the gift and estate tax. So now the good news is I'm putting up this slide here with the history to let you know that we were concerned that it might drop to 3.5. September 13th, the Ways and the Means Committee of the House of Representatives issued their proposal. And in their proposal, they were proposing to drop it to 6 million per individual. So right now, if you were to die, you have 11,700,000 that you can transfer. So President Biden wanted to drop it to 3.5. The House of Representatives, their Ways and Means Committee, had proposed 6 million, so 6 million per individual. As we've been tracking this through the fall and into the winter months here, that is not likely to pass before the end of the year. So as of right now in 2022, it's looking like we're still going to have the higher exemption. And that's important because historically, the only time we've ever seen the exemption drop, and it really wasn't a drop, it was 2010, the federal estate tax had gone away. And so starting in 2011, we would have seen it come back in at a lower amount, obviously, because in 2010, you could gift as much as you want without any tax. So that was the only time we saw it drop. And I don't really consider that a drop. It was that in 2010, they were saying there was no federal estate tax. So if Congress and then the president would sign something new in 2022, it would be the first time that we've seen a drop in the federal estate and federal gift tax. Okay. So as of right now, what it's looking like is that the annual exclusion in 2022, starting January 1st, will be 16,000. That means that bumps up from 15,000 to 16,000 that you can transfer to as many donees in 1 year as you want. Or if you're a husband and wife and you want to split the gifts, that would be 32,000. That's an increase from the 30,000 that you could do. This is all tied to, sometimes I still have people say, well, you can gift 10,000. They are correct. If you looked at the IRS code section, it would say 10,000. It's just that's been adjusted for inflation over the years. So in 2022, accounting for the adjustments of inflation, it's 16,000. The federal estate tax and gift tax exemption is 12.06 million. It's an odd number. It's not ideal when practitioners, when we're trying to, tell people it would be nice if it was just a flat 12.1, but it's 12.06 million. And again, we're going to keep an eye on that. I know that in the fall, we sent a lot of clients an email that said, hey, we're watching this. These are some things to be concerned about. So we certainly do keep an eye on that to see if the federal exemption would be dropping. And if so, what would it drop to? But we're now at, December, mid-December. So it doesn't look likely that anything will pass before the end of the year. Okay. So that was a very long discussion about the history of the federal, state, and federal gift tax. One of the other things I wanted to make sure everybody knew, now, again, this doesn't matter for Medicaid purposes. We haven't gotten to any of the gifting rules for Medicaid at this point. But know that for federal gift tax, not only do you have the annual exclusion amount that you can gift every year without even having to file a gift tax return, you also have gifts that aren't considered taxable. They're excluded when it comes to gifts. So we talked about the first one, that's gift not in excess of the annual exclusion for that calendar year. It's important to note that if your husband and wife and you're going to be gifting in 2022 $16,000 and it's out of a joint account, I would recommend that each spouse write a check and sign it so that you don't have to file a gift tax return. If you do it in one check and you put $32,000 in 2022, still not, we don't have to worry about tax, but you do have to file a 709, a gift tax return, because you're splitting the gift. Because again, you yourself don't have a full 32,000 in 2022. It's allocated 16 and 16. So you have to make sure that if you're going to write it in one check, that you file a gift tax return, a Form 709. If you do it in two separate checks and have husband sign one check and wife sign the other, then you don't have to worry about filing the 709. Second thing is tuition or medical expenses if it's paid directly to the institution. So when I was in college, for example, my parents were generous. It would help me out a lot with tuition, and they would pay a certain amount, to help out. And so one of the things that we learned the hard way was that if my dad wrote the check to me, I deposit it in my bank account, then that's, part of that annual exclusion gift to me. But if he had written the check directly to the college for tuition, now it's not for room and board, it's for tuition. If he made it directly to, I went to Penn State, made it directly to Penn State, then my dad could then gift me an additional annual exclusion. So if the annual exclusion was 13,000 or 14,000, whatever it was at the time I was in college, it's been a while, my dad could pay the tuition or pay towards the tuition, plus he could still have transferred that annual exclusion amount to me. So I always like to make sure to tell people that, because I'm just not sure that a lot of people recognize that if you make it directly to the college or university or to the medical facility, then that doesn't count towards a gift. So it gives you more that you can actually transfer to that individual. Another thing that doesn't count as a gift is to a spouse. So if you wanted to be really generous and you wanted to write a check out to your spouse, maybe you have separate accounts, you can do that and you don't have to worry about having to file a gift tax return. And then number 4 there is any political organization or charitable organization that you're writing gifts to. That doesn't count towards your annual exclusion amount either, nor does it use any of your exemption. So that's another way that you can make some gifts. How many exclusions are available? We talked about this. As many people as you want to gift the annual exclusion to, you are welcome to do that. And if you would have a family, and this just gives the example where you would give, multiple people the annual exclusion amount. If you husband and wife would split it, then potentially you could save a good bit of tax that way. So always think of the annual exclusion. And just like any seminar that we're doing, we're kind of building on the knowledge. So keep in the back of your mind knowing that you have this annual exclusion amount, because when we start tying it into trust and gifting into trust, this is going to be important. Okay, so know that 2022, you can gift 16,000 per individual. If you want to, if you're a very generous soul and you want to gift 15,000 for Christmas this year, and then in January turn around and gift 16,000, you can do that. It's in the calendar year, so you can do it in December and then turn around and do it in January. All right, ways to deal with the gifts. Okay, so we're going to go through some of these. So we already talked about some of the medical ways, the educational ways. Another way that I wanted to talk about was trust, gifting in trust, because I know that there's a lot of questions about life insurance trusts, ILITs, gifts into trust. So I wanted to spend some time talking about that. I also want to talk about 529 plans and UTMA accounts. And then we've talked about some of this in one of our previous slides, but I wanted to talk about transferring property for $1. And I wanted to talk about the gifting implications, but more importantly, the basis implications. So with that being said, medical and educational gifts, we talked about that has to be made directly to the medical services provider, so the doctor's office, the hospital, or directly to the educational institution. And again, this doesn't count towards your annual exclusion. The other important thing to know is that this transfer that you make to pay tuition or medical expenses doesn't have to be anybody related to you. So again, if you wanted to be extremely generous to a family friend, anyone else, you can do the same thing there as well. Okay, let's talk about transfers to trust. So we talked a lot about the gifting, the federal, state, and federal gift tax implications. So let's talk about transfers to trust. And this is important because a lot of times your children or the people who you want to be gifting to aren't in a place where you just want to write them a check for that annual exclusion amount. Or let's say that you have a federal estate and you want to gift a larger amount to use up the exemption. So for example, we have a client who wants to gift the 11.7 million that they can gift, and they want to do that before the end of the year because they have a spouse who passed away and they already have locked in their deceased spouse's exemption. So what husband wants to do is he wants to use up his exemption, gift as much as he can, in the hopes that then when he passes away, he'll use wife's amount that he got because of her death, and there'll be no tax that's due. So in this case, we're talking to him a lot about transfers to trust, because it's one thing to write a check to somebody for $16,000. It's another thing to have an $11.7 million check. And we don't, most of the time, want beneficiaries to be able to receive that lump sum. So if it's an amount that you want to be able to transfer into trust, then we want to talk about that. So Section 2503 is the IRS code section that talks about annual exclusion gifts. That's where if you go to the Internal Revenue Code section and you look at 2503, you're going to see a reference to $10,000. And the reason why that's in there is because when they enacted it, it was $10,000, but it does allow an adjustment for inflation. The reason I'm referencing 2503 is because it's talking about how this annual exclusion amount that the person who's receiving has to have a present right to enjoy it. So that's under the Treasury Regulation 25.2503-3B. And it defines a present interest as an unrestricted right or access to possession or enjoyment of the income or of that property. Okay, meaning that my parents can't say, well, Sam, we're going to gift you, and I'm using the quotations, we're going to gift you something, but you don't have access to it. You don't have the ability to control it. And so the IRS's point is, well, then is it really considered a gift, and should it qualify for the annual exclusion, that free amount that you're allowed to transfer to as many people as you want every year? So the IRS put in their regulations, their Treasury regulations, that said, no, it has to be an unrestricted right or access to possession or enjoyment, either to the asset itself or to the income from that asset. So if we transfer it to a trust, so if mom and dad set up a trust for me and they transferred in, and let's say that mom and dad said that, okay, we're going to transfer, in this example, let's say they want to transfer 100,000 into trust for me. And there's a lot of reasons they might want to do that. The first is that, they might not want it to be available to my creditors. They might not like a spouse. They might not like, some choices I've made in life. So they may say, let's put it in trust. Let's put 100,000 in trust for Sam. And then the trust provisions would outline when the trustee can make distributions to me. So if the trust document is saying, okay, well, we're going to put 100,000 in, but Sam's only going to get $1,000 a year. Okay. Well, that means I don't have unrestricted right and access to that 100,000 that they transferred into trust. So the IRS would say, well, we're not going to allow it then to qualify for the annual exclusion. So what that means is if mom and dad had transferred 100,000 and they had given it to me outright, they could take 100,000 and in 2022 they could minus the 32,000 annual exclusion, and then they would just be making a gift of the excess of that. Okay. So if they'd done it to me outright, it would be less a gift. It wouldn't be the full 100,000. But if they transferred it into trust, the IRS would say, if I'm only getting a certain amount, that, because I don't have access to it, then it doesn't count for the annual exclusion. So some attorneys decided that, there has to be a way that we can allow this to happen. So what they came up with is what we call a crummy withdrawal right. Now, I get asked a lot, why is it called a crummy withdrawal right? So it has nothing to do with how we feel about the withdrawal right. If you notice, the crummy is spelled a little differently than we would normally spell the word crummy, meaning that we like this withdrawal right. It's not a bad withdrawal right. But the reason why it's called crummy is because the gentleman, the client that this attorney was working with, their last name was Crummy. And what the attorney had done is they set up a trust and they put crummy withdrawal rights, which just means that in the trust document, it will say for a specified period of time. So usually we see 30 or 60 days is kind of the standard. 60 days you see more often. But what the trust document says is it says anytime the person who created the trust, the grantor, so in this case, mom and dad, my parents, set up the trust, they're the grantor. Anytime they transfer anything into the trust, there's a period of time, so 60 days, in which after they transferred into the trust, in which I have the ability to withdraw those funds. And because I have that ability, even if I don't withdraw those funds, me merely having the right to withdraw it will mean that I had a present right to use the assets in the trust. And because I have that present right, then any transfers to the trust, whether or not I actually exercise the withdrawal right, will qualify for the annual exclusion amount. Okay, so in the example, if mom and dad transfer the 100,000 into trust, and then I have a 60-day window of time in which I could withdraw those funds, then the IRS would say that meets the 2503 qualification of it being a present right to withdraw. So they could use 100,000 minus the 32,000. So you get the same result if they transferred to me outright or whether they transferred it to me in trust. And so this is a beautiful technique that we're able to use in trusts. The most often trusts that use this are life insurance trusts. So we call them ILITs. An ILIT just stands for Irrevocable Life Insurance Trust. It's ILIT, so we call it an ILIT. Now, the reason that we need crummy withdrawal rights in an ILIT or in that life insurance trust is because what's happening in that situation, if mom and dad, let's say dad has a life insurance policy where he's the owner and the insured, the death benefit. So let's say they got a really big policy that has a $2 million death benefit when my dad dies. That $2 million is included in my dad's federal estate. Even though he dies, he's not getting it. It would be paying to me. The IRS says that value has to be included in my dad's estate when they're calculating whether or not it's subject to federal estate tax. So life insurance is an asset that the owner has to include in their estate, and they really don't get a benefit from it. So we use ILITs or life insurance trusts. So either dad would transfer the policy into this trust, or the policy would be purchased by the trustee of the trust. Either way, once the life insurance policy is inside the trust, how do we pay the premiums? Because there might not be any other liquid money inside the trust. It might just be this life insurance policy. So we have to figure out a way to transfer funds into the life insurance trust so that the premium can be paid by the trustee. Otherwise, every time my dad pays the premium on a policy owned by an ILIT, he's making a gift to me. So instead, what my dad would do is the trust would have a 60-day window in which my dad would transfer whatever the premium is for that life insurance policy. So let's say the premium is $5,000 a year. So what my dad would do is he would write a check payable to the life insurance trust for $5,000. Then whoever the trustee of the ILIT is would have a bank account titled in the name of the trust, and they would deposit that $5,000 check in that bank account. Then that would have to sit there for a 60-day period of time in which I could withdraw it if I wanted to. I'm not going to, because if I withdraw it, then the premium can't be paid. If I let it sit there, the trustee can then cut a check payable to the life insurance company for the amount of the premium. And what that does is it allows the $2 million life insurance policy to get out of my dad's estate, and I get the death benefit of $2 million tax-free. So I'm not going to want to exercise my withdrawal right, because if I do that, then it makes it more difficult when dad dies, because he's been making gifts to me all along that use up the annual exclusion. And so I'm going to say, no, I won't withdraw. I'll let it pay the premium knowing I'm going to get that $2 million. So that's why crummy powers are important. We see it most often with life insurance trusts, but it would be for any asset you transfer to the trust, including real estate. So we do have some clients who have a federal estate we had transferred gas interest as well as surface rights into a trust, and we used crummy powers so that we could transfer more into the trust without using up their exemption. So that's a really long way to explain why crummy powers are in there and they're good to use. Okay. All right, so the next thing I have is a visual here. And I have this in here because we use a lot of these trusts for Medicaid planning. We use what we call a protector trust. And I wanted to point out that for Medicaid purposes, the transfers into these trusts are considered a gift, meaning that it's subject to the 5-year look-back period. But for federal gift tax purposes, these trusts are not considered a gift. So you don't have to file a gift tax return. We know that when you pass away, there will be a stepped-up basis in these assets. So know here at our office that we use both ILETs, those trusts that get out of the estate, and we use Medicaid trusts to protect against creditors, including a nursing home. All right, I wanted to mention to people here who are attending the virtual seminar, as well as anybody out there in the cyber world who's listening to this after the fact, that you should be gifting to your spouse if you're concerned about federal estate and federal gift tax. Because remember, you can gift 15, soon to be 16,000 to as many people as you want. That includes a spouse. So if you set up a trust for your spouse, or if you transfer to your spouse, and let's say we just even use a 15-year period in which you transfer 15,000 every year to your spouse, the benefit is you'd be able to get 225,000 using the 15,000. That would increase with 16. You'd be able to get that out of your estate, and it's out of your spouse's estate, because if you gift it to them in trust, they don't have to include those trust assets in their federal estate. So it would allow you, if you do it in enough time, to exhaust your estate and to be able to put it into a trust that's out of your spouse's, out of their estate too. So if we have clients who are concerned about federal estate tax planning, you can do that. You can do it in what we call a spousal access trust. And that's a trust where the spouse as well as the descendants are beneficiaries there. And we've used that for some high net worth clients. And it's been really helpful. We still need the crummy withdrawal powers. And spouses can't split the gift then, because if husband sets it up and wife is a beneficiary, he can't split the gift because we can't have spouse making a gift to herself. Okay. So these are all fun things that we can talk about if you're ever worried about federal estate tax concerns. The next thing I wanted to talk about is discounted gifts, which allow us to leverage our gifting amount. So we see this a lot with family-owned businesses. They either have a family-owned partnership or an LLC already created, or they want to use this type of structure to get discounts. So if you think about it this way, if the annual exclusion amount, the soon to be 16,000, if you can gift that every year to as many people as you want, if you have some assets, so like maybe you have a family farm or a lot of real estate and you want to put it all into an entity, so it's all managed in one entity, and then you want to slowly transfer this to the next generation. We call that pattern gifting. And what you're able to do is you're able to gift a percentage of the FLP or of the LLC that equals the annual exclusion amount. You're able to gift that every year to children or to the next generation, and it allows you to not use up your exemption. The beauty of using an FLP or an LLC to do this is not only can you do it using your annual exclusion, transferring a little bit at a time, but it also allows you to get some discounts. So the IRS says if it's a family-owned business and there are transfer restrictions in the governing document. So most often we see that if we take mom and dad, and then my sisters and I, there are 4 of us. So if they created an LLC and they maybe put a farm in there, other real estate in there, and my dad, as well as my sisters and I and my mom signed a governing document called an operating agreement. If we sign something saying that we're agreeing not to transfer our ownership interests to anyone other than other family members in the immediate family, we can define that to be siblings or maybe children or a parent. So back to mom and dad, we can only transfer it to those individuals. And if we have those type of restrictions and it's actually in writing and we've all signed it, then there are 2 discounts that we could potentially get. One is a lack of marketability, and that's saying that not everybody's going to want to be a part of our family business because they can't sell it to just anybody. They can only sell it to other family members. And if I only own a 25% interest, then I'm a minority in that business. So it would, taking both of those things together, a lack of marketability, and if I'm in the minority, meaning I own less than 51%, so usually it's around 25-30% is what other family members own. If that's the case, then typically you can feel comfortable taking a discount of 30%. So what does that look like? Here's an example. So let's say we have a family that has an LLC that owns real estate, maybe some oil and gas interests, the family farm, and we have governing documents that put transfer restrictions, meaning you can't transfer ownership to anyone other than immediate family, so another sibling, maybe a child, or to a parent without written consent. That would give us the lack of marketability, because not everybody's going to want it then. They can't sell it on the open market. And let's say that I only have a 25% interest in it. Well, then what happens is that if the LLC is valued at 4.2 million, with a 30% discount, the total LLC would only be worth 1.2 million. So it would allow parents to transfer a larger percentage every year without making a large gift, because you can discount it. Now, what you have to make sure that you're weighing is you want to make sure you're working with a legal professional, because you have to make sure that there's still the present right. Because remember, we need a present interest in the LLC to be able to get it to qualify for the annual exclusion. Remember that 16,000 in 2022, the Treasury regulation says that we have to have unrestricted enjoyment. So we have to make sure the governing document doesn't go too far with the restrictions, but we need there to be some restrictions so that we can get the discount. And that would allow mom and dad to transfer a larger percentage every year to the children without making larger gifts because of that discount. And so we see this be very successful when we have clients that do have high net worth. Now, of course, there's always some cons to it. So in Pennsylvania, for example, there's realty transfer tax with certain business entities, so we have to worry about that. Of course, you're going to have to do, your annual meetings. You're going to have to do all of the filing that you need to do. So it's not without some negatives, but when we have a client who is concerned about federal gift or federal estate tax things, then we can use this as a way to get more out of their estate. The next thing I want to talk about is children's trust. So I wanted to put this in here because, again, there are going to be certain times where you do not want your beneficiary to have the ability to withdraw. So when we talk about the life insurance trust and that 60-day window in which I can withdraw the funds, the crummy withdrawal right, know that that means that for those 60 days in which I have the ability to withdraw, it's available to my creditors. So we don't want to miss the bigger point here, which is if you want restrictions and guidance and you want it to protect it for a child who has special needs, or you want to protect against death, divorce, disability, or any in-laws there, then you may not be able to have a withdrawal right in there. So again, it's balancing the creditor protection versus the gifting issues that you're going to have. So I wanted to make sure to bring that up, because a lot of times we have clients who may opt not to put crummy withdrawal rights in there, and that's merely because there are some creditor concerns that they have about children. And so they would want to put restrictions and have that creditor protection. And this is more about a children's trust. It's talking about how you need to make sure that, you're putting withdrawal rights at certain ages, if that's what you want. So we're going to move past that, and we're going to fast forward a little bit. So let's talk about college saving plans. So these are a different way you can gift. So we're moving slightly away from the trust, and then I'm going to bring it all back together and explain why I talked about the trust and why we're talking about these other ways that you can gift. So we have 529 plans. We have a lot of clients who set this up for grandchildren, especially. So it's just a 529 plan. So you set it up, you're allowed to transfer in there. So if 2022 you set it up, you can transfer the 16,000 every year. What's in addition is that you can front load it, which means that you can say, okay, I'm going to take 5 years worth of my annual exclusion. I'm going to put it into this 529 plan in the first year. So if you were to do that when it's 15,000, that would mean that you could potentially, as a couple, front load it with 150,000 in the first year. Now, the downside of that is if somebody passes away, if the beneficiary of the 529 plan passes away within those first 5 years, there are some implications to that. But you can do it. You can front load it. And then the beneficiary can use those funds for qualified higher education expenses, such as tuition, books, room and board. It can be used up to $10,000 a year for tuition K through 12 education. Okay, so that's the other thing to remember. The downside of the 529 plans is that they're subject to income taxes and a penalty if you withdraw them, if they aren't used for that purpose. So let's say that you have a grandchild who you put money in a 529 plan, and then maybe they don't go on for higher education. Now, what you could do is you could change the beneficiary. You'll have to swap out beneficiaries. So if you have one grandchild who's going to college, you could move the 529 plan to that beneficiary without having a penalty or having to pay income tax. But if you wanted it to go to the benefit of that beneficiary and they aren't using it for those qualified funds, then that 529 plan can't be used without paying the income tax or the penalty. So that's one of the negatives of a 529 plan. An UTMA account is a uniform transfers to minor account. So this is where you have a guardian who's appointed and you're going to put funds in an UTMA account for that guardian. We see this a lot when someone passes away, if they have beneficiaries under a certain age. Pennsylvania, it can be all the way up to 25. You can direct the custodian to hold those funds for that underage beneficiary in an UTMA account. So there are some tax consequences there. There are some issues with financial aid if they would be applying for scholarships or funding through the schools. So, and this is what we talked about. So it may make them ineligible for any scholarship programs or initiatives that would be based on their needs, because these all count towards that. Okay, so that would be the negative of the UTMA. And this is where we talk about how you can open it up, you can contribute those funds, depending on the plan. It's either 18 to 21. Most of the time it's 21 we see, and then at that age they receive those funds. A lot of times we see it on the estate admin side of things where nobody retitled it. So if it was in, for example, grandparent and grandchild's name and the grandchild's now 25, but nobody retitled it, on the estate planning side of things, then we have to work with that. We actually had somebody who the grandchild was in their 30s. And so originally we were concerned about having to pay inheritance tax, but we were able to get the child just in their name to be able to say, well, no, when they turned 21, it technically was their asset. So we didn't have to worry about it. So UTMA and 529 plans versus the trust. So I am an advocate for 529 plans and UTMA accounts. I think they have a great purpose and use. The concern I have, and this is, when we talked about the whole fact that 529 plans have to be used for education, this is my concern in addition to that. So my other concern is that 529 and UTMA accounts are considered available for the owner's long-term care. So if we have grandparents who are setting up 529 plans and they're the owner on the plan and it's for the benefit of their grandchild, that 529 plan is available if they would ever need long-term care. So I always like to talk about UTMA accounts, 529 plans, but I also like to talk about it in conjunction with a trust. Because if you're gifting and you are concerned or, you have thoughts that maybe there could be some long-term care that you might need, then remember that's subject to a 5-year look back. And so doing a trust earlier, what it does is it allows those funds to be owned in the trust. It can be used for anything, education, as well as any other purpose. So if you have a grandchild who's an entrepreneur, instead of the 529 plan not being able to use for that, the trust can make distributions for that. And from a long-term care planning perspective, it's protected against long-term care costs. So always, when you're meeting with an attorney, you want to make sure that whatever trust you're doing, you're talking about what does this do for long-term care purposes? Is this protected? Is it subject to my long-term care? And so a lot of times, most trusts that we use here in our office, unless it's a revocable living trust, whether it be a trust we're doing for Medicaid or whether it be doing an ILIT, a life insurance trust, those trusts are going to be protected against your long-term care costs once you make it through the 5-year period. So that's why if I had to say which do I prefer, from a legal perspective, I prefer trusts. But we have some situations where we talk about it with the client and they decide to go with an UTMA or 529 plan. And I think that works great. As long as they know the pros and the cons, they can figure out what works best for them in that situation. Okay, so let's talk about tax implications of selling your home to your child. And I use sell in quotations because as we talked about in one of the first slides, is that if you're transferring it for $1, it's a gift. It's not considered a sale at that point. So what does that mean? So of course it's a gift. And so the question is it above your $16,000? And if so, then technically the IRS says you have to file a gift tax return. The more important thing though, is what does it do to the basis? So basis is the equity that you have in the asset. So if your house is worth $200,000, but you bought it, let's say for $100,000, your basis is $100,000 in that house. So if you sold it, you would have a gain, the difference between the $200,000 that it's worth and the $100,000 that you purchased it for. There would be $100,000 that would be subject to capital gains. Now, if it's your primary residence, you can shelter that, okay? But if you're adding your children or gifting it to your children, it's not, most of the time, it's not their primary residence if they're adult children. So what that means is if you transfer it for less than fair market value to your kids, they get carryover basis, meaning that if you purchase the house for $100,000 and you gift it to them, their basis in the house is $100,000. So if they sell it at your death, they're going to have to pay capital gains on the difference between the $200,000 sale price, the $100,000 of carryover basis. So they will pay capital gains on $100,000. Right now, that's 15% or 20%, depending on your adjusted gross income. We do anticipate that the capital gains rate would increase. So if you still have the house in your name at your death, they will pay 4.5% inheritance tax on the date of death value. So they'll pay 4.5% on $200,000, but they get a stepped up basis. So their basis in the property is now $200,000. If they turn around and liquidate it, $200,000 minus $200,000 is zero capital gain. And because the capital gain rate is 15% versus the 4.5, it was better for them to have paid the 4.5%. So you want to make sure that when you're thinking about avoiding inheritance tax, are you just allowing or setting it up for your children to have to pay income tax at a higher rate? All right. This is just a nice long-winded step-up basis explanation. I told you about it in the example. So this is kind of all of it in writing, talking about the contrast between step-up basis and carryover basis. One thing I will note here, President Biden's agenda in the spring of 2021, he proposed to get rid of the stepped-up basis for income tax purposes. When the proposal came out of the Ways and Means Committee on September 13th, that was not in the proposal. So meaning that as of right now, we still get a stepped-up basis. Now, regardless of what anybody thinks about taxes, political, all of that, if they get rid of the stepped-up basis, it will be a little bit of a nightmare for everybody. And the reason is because a lot of people are inheriting property through the family for years and years and years. So their basis is going to be zero if they don't get a stepped up basis. So it creates a little bit of an accounting nightmare trying to trace the basis. I think more often than not, people are going to end up with a zero basis because they can't prove a higher basis. So there's a lot of accounting reasons why we like the stepped up basis. We like it for tax purposes too, but we like it for accounting purposes as well because it makes it easier. We know that if you owned it on the date of death, you just get a stepped up basis based on the fair market value on the date of death. So we're going to keep an eye on that. So it disappeared from the Ways and Means proposal that came out September 13th. Interestingly, it's still on Biden's tax agenda for 2022. So we're going to keep an eye on that. If they get rid of the stepped up basis, then know that there's no benefit to paying inheritance tax. So if they get rid of the stepped up basis, a lot of our practice may shift to going ahead and gifting it out of the estate because we don't have to worry about needing to get a stepped up basis. If there's no stepped up basis to have gotten, then we might as well avoid the inheritance tax. And so we'll keep you updated if we see anything like that coming through the legislation. All right, let's shift a little bit to Medicaid. So the first, I was going to say half, but the majority of the seminar today has been about federal gift and federal estate tax planning. But I did want to mention Medicaid. And the reason is because we do a lot of Medicaid planning and asset protection here at our office. And so if you're trying to qualify for Medicaid to either cover for nursing home care or the aging waiver program in Pennsylvania, the look back period is 5 years in Pennsylvania, and that's for any gift over $500 in any month is going to be subject to the 5-year look back period. And that's the maximum is the 5 years. However, if you gift less than that, your look back period may be less. So for example, let's say that mom and dad transferred $100,000 to me. I'm looking down because I'm running it on my calculator. So $100,000. I divide 100,000 by the $11,099. That is the penalty advisor, meaning every year Pennsylvania says that for every amount, and they fill that in every year, by every $11,099 that you transfer is 1 month that the Medicaid won't cover. So if mom and dad transfer 100,000 to me and need care within 5 years, that transfer, I take 100,000 and I divide it by $11,099, and it gives me a 9-month penalty period. So when we say a 5-year look back period, that's the maximum look back period. But if you're not gifting as much, you can actually have a lesser look back period. But know that it is for any transfer of $500 or more. This is horrible when we're trying to put together the Medicaid application. So we help people file for Medicaid if they need that. And we have to pull the bank statements for the last 5 years, and we go through and highlight every transaction of $500 or more, and we have to explain it. So if it went for electric, or somebody was cutting down trees and they're paying their landscaper person to do that, we have to explain every amount over $500. So it's a little bit time consuming when you're trying to apply for Medicaid. So know that when we're talking about federal, state, and federal gift tax, yes, the annual exclusion is going to be $16,000 in 2022, but any amount over $500 is going to be subject to the 5-year look back period. So yes, you can add your children's names, but know it's going to be a gift, and there are basis concerns there. There are federal gift and federal estate tax concerns, and it also creates some creditor concerns. And we've talked about this before in other presentations, subject to their death, divorce, disability, and any other debt that they would have. So alternatives to making gifts for Medicaid. So when we have clients who are coming in and are worried about that, a lot of times we'll talk about, well, maybe you want to use a trust. And we use those trusts in that visual that we saw previously in the slideshow. Those are the type of trusts we use. So we'll say, okay, maybe we want to gift and trust and make it through the 5-year look back period. Maybe we want to purchase it for the fair market value if it's real estate. Maybe we want to look into some sort of insurance product. So know that there are alternatives to gifting, but our preference is that you should do the planning in plenty of time to make it through the 5-year look back period, because then you can gift it in trust. And those assets will be there for your spouse as well as the next generation. Gift to charities. This is my last point. I think it's my last point. So we will do a whole seminar on charitable gifting, because that could take an hour in and of itself, an hour plus, to talk about charitable gifting and charitable giving and all the different options. But know that you can also make gifts to charity. Now, the difference between charitable gifts is, remember, we don't have the 16,000 cutoff, okay? So you can give larger amounts to charity, but you have to cross-reference that with the income tax rules, because again, for income tax purposes, there might be a limit. If you're trying to get a corresponding income tax deduction, you have to make sure that you're following the income tax rules. So under Trump, you could gift and then deduct up to 60% of your adjusted gross income. But you could only deduct the charitable gifts if you were itemizing. If you were using the standard deduction, you weren't able to deduct those gifts. So I wanted to kind of close on that, just saying, as we're going through the holiday season, if it's something where you're looking to gift to charities, you can do that. You don't have to worry about any caps for the annual exclusion amount. Don't have to be concerned about that. The only thing you had to be concerned with is if you're doing it to get a charitable deduction. You can only do that if you're itemizing for income tax purposes, and you can only do that to the extent that you aren't gifting more than 60% of your adjusted gross income. And I'll leave it at that, knowing that we'll do a separate session on gifts to charities, because there's all kinds of charitable gift trusts that you can use. We'll talk about donor advised funds, all of that good stuff. I'm excited just thinking about it. So we'll do a whole separate session on that. So on January 27th at our noontime hour, we're going to talk about the tale of Robin Hood and the new taxes. So I'm not sure if we'll have new tax stuff to talk about, but even if we don't, I want to talk about what we're seeing, because again, there's all kinds of literature and articles about, what we're thinking that the next year will hold. So I'm excited about that. I love talking about taxes, and so we'll be talking about the tale of Robin Hood and the new taxes. You can register by emailing Amy and her email address. You can call us at 717-655-2676, or you can visit our website. And I will tell you that if you go to our website, you can always explore there. We have a lot of links to other information, including our YouTube channel. So anytime we do a virtual seminar, I also do 2-minute what if videos where I answer short questions. So go to check out our website, as well as you can always check us out on YouTube. We have a channel. You can subscribe and get notifications whenever we post a new video. And Amy will be emailing a link survey for any feedback that you guys might have, any new topics, anything you want me to cover more in depth, or if you just have any general questions about gifting, you can always put that on the survey and we'll get back to you. All right. That being said, I want to thank everybody so much for being here. What I'm going to do is I'm going to stop recording, and I'm happy to take any questions. So I'm Samantha from the law offices of Samantha Wolfe. You can reach us at 717-655-2676, and we're here if you have any questions. Thank you so much.